affirmatively established that neither party had given their consent to the communication.
Did he speak to those two officers before he made the arrest?
No, Your Honor.
How did he know that they hadn't given consent?
And so, Your Honor, the way that the statute is framed, or perhaps those 10 states that interpret it this way, it's about whether Mr. Franklin had the consent of both parties, and where Mr. Franklin affirmatively states on the record at page 5 that he did not. I'm not sure that it would have been necessary to double-check his answer with Officer Phelps and with, and I see that my time has expired.
Can I ask you one more question?
Certainly.
With regards to the third prong of your argument, which ultimately gets to the merits of the Fourth Amendment claim, your position is that upon any arrest with either probable cause or arguable probable cause, any electronic device that you have on you is fair game for a search. So if you, and I don't mean you, but someone happens to be wandering outside after having a little bit too much to drink, after a tough day of classes, and happens to have his or her iPad and computer and cell phone, and a police officer makes an arrest for public drunkenness, he or she can just decide to have fun and go through all of those devices for whatever they're worth. Yes or no?
No, Your Honor, but if you will forgive a follow-up long-winded answer, and it's that, first of all, under this court's precedent in Gruen versus United States, no additional justification is as a legal matter required to search the contents of anything that's, or not the contents, but search anything that is incident to the arrestee's person. And that a search incident to arrest is always tempered by reasonableness, which was this court's opinion in United States versus Robinson. And as Judge Posner elaborated upon, specific to cell phones and other technological devices in Flores versus Lopez, such reasonableness is often a matter of three things. First, whether the search was narrowly tailored, as it was in this case, often to the very reason under which we arrested the respondent in the first place. So where there is admittedly a heightened expectation of privacy that we have in our personal phones, our personal computers, oftentimes those expectations of privacy must give way to legitimate state interests, and it's consistently a balancing test. There is no per se rule for cell phones. While there is unanimous circuit consensus that there is a presumption of legality in searching pagers, the contents of address books, we don't define the reasonableness of a search incident to arrest by the nature of the object. We define it by the balancing test. And so when the search is reasonable, oftentimes the heightened expectation of privacy will give way to the legitimate state interest. In your hypothetical, it's perhaps possible that the state interest would not have been legitimate enough to overcome anything more than a slightly invasive search, which, as in this case, Officer Lochte did no more than open the cell phone to determine if perhaps a further exigency existed, closed the cell phone, and proceeded no further. And so for the foregoing reasons, we respectfully request that this court grant summary judgment in Officer Lochte's favor. Thank you.
Thank you very much.
Good afternoon, Mr. Chief Justice. May it please the court. My name is Jonathan Gaynor. Together with my co-counsel, Sara Gruen, we represent the respondent, Mr. Michael Franklin. I'll handle the First Amendment issue. My co-counsel will be handling the Fourth Amendment issue. Qualified immunity protects officers from meritless suits. It balances the difficulties of serving the government against the vindication of the constitutional rights of the individuals involved. It is because in this case, the constitutional rights under the First Amendment were clearly established that we urge you to affirm the holding of the 14th Circuit. I offer two reasons on the First Amendment grounds to show that we have a clearly established right that's been violated here. First, that this restriction was based on the content of the speech itself. And second, that this restriction, this arrest, violates Mr. Franklin's right to report on police activity that occurred in public.
That just means you may win on the merits, but you may never get to them unless you show that the officer is not entitled to qualified immunity.
That's right, Your Honor. And I'm prepared to discuss both the merits and the clearly established prong of the qualified immunity test at the same time. The court asks us to look very carefully at the right at issue, to look at the specific facts and circumstances, and to weigh them against the situation and what the case law says. It's not necessary, after Hope v. Pelser, to have a materially similar case on point that says exactly what happened in this factual circumstance. The salient question under qualified immunity is whether the officer has reasonable notice that his conduct violated constitutional law. And so by exploring first the content-based nature of this search, we can look at the record on page 5, paragraph 8, in Officer Lochtey's own affidavit. He describes the circumstances under which he arrested Mr. Franklin. He says he did not intend to arrest him until after Franklin said, "Wait a minute, Phelps is one of you." This kind of reaction to the content of the speech falls squarely within what could be regarded as content sensitive. The court recently held in Snyder versus Phelps, the Westboro Baptist Church case, that one way to test to see if a regulation is based on the content of the speech is ask yourself this question: if the content were different, would the regulation have occurred? In the Westboro Baptist Church case, they held up signs saying "God hates you" at funerals for members of the military who died in Afghanistan and Iraq. And the court there held that restricting their speech just because the message is unpopular or the message is inconvenient is against the Constitution.
But the arrest here was for an alleged violation of the wiretapping statute.
Respectfully, Your Honor, he says that it's for the alleged violation of the wiretapping statute, but he also says in the record he didn't intend to enforce the wiretapping statute against Mr. Franklin until after he learned the likely content of the cell phone video.
But police officers have discretion that they exercise every single day to decide whether or not to enforce the law. That may be a good thing or a bad thing, but it happens every single day. You or I get pulled over for driving a little bit over the speed limit, and we hope, we pray, that that officer may decide not to exercise his discretion to give us a ticket. But no one would say that that use of discretion is unconstitutional.
You're absolutely right, Your Honor. We have evidence, though, in this particular protest that the individuals involved were constantly recording each other, constantly recording anyone around the protest area, and then posting that information on the 99percent.com website. We have from the officer's own affidavit in paragraph 8 saying, "I wasn't going to enforce the wiretapping statute against him until I found out he said, wait a minute, Phelps is one of you." So in this instance, while we do allow officers significant discretion in the exercise of their authority, when we have evidence that that discretion is being used in a way to specifically regulate the content of speech, we have a clear violation of someone's
Should we also look to your client's intent? It didn't appear he was filming this for purposes of showing the message of the movement, but to catch the undercover police officer in the act, if you will. So isn't this different interest here than what the other cases talk about?
Justice Rockford, the answer is no. The reason is that the government has no business in going into the content of speech. He could have been posting, "What a lovely day." He could have posted, look at our leader working with the police peacefully to resolve our issues. He instead posted, "Why is Phelps so chummy with the NLPD?" His message, be it critical of the government, neutral toward the government, or completely irrelevant to the government, doesn't bear on the First Amendment protections involved. Now, you may be alluding to the...
Violate the wiretapping statute?
Respectfully, Your Honor, he did not. My co-counsel will be arguing more about the nature of the wiretapping statute when talking about the Fourth Amendment issue. It's more relevant there. For my purposes, and this reaches the second part of my argument, the central question is whether the wiretapping statute is a valid time, place, manner restriction over this conduct, and whether the application of that wiretapping statute is overbroad or not.
But you seem to be focusing on the intent of the officer, and at least in terms of arrests and probable cause, the court has really never ventured into that sort of analysis. It'd be a nightmare to enforce for district judges, for trial judges, where every single time there was an arrest, there would be all sorts of inquiry and maybe discovery, if you're able to get it, on the subjective motivations or beliefs or intent of the arresting officer, as opposed to looking at whether or not objectively there was probable cause to arrest. That's a hornet's nest.
Respectfully, in the usual case, I would agree with you. In this case, however, we have the officer giving sworn testimony about his reasons.
But that can't be a principled reason to do it in this case. So the principle you want us to draw is, if the police officer is dumb enough to talk about his subjective motivations, then you can get into his motivations. But if the police officer is smart enough to keep quiet, then it has to be an objective standard. That can't possibly be a rule of law that we're going to prescribed to trial judges.
Respectfully, Your Honor, it was the rule originally. Qualified immunity started out as good faith immunity, and it started out as an inquiry into whether or not the person was enforcing the constitutional law in good faith. We've departed from that kind of inquiry for precisely the reasons you've articulated. We don't want to spend a lot of time during discovery going into the subjective intent of the officers. But in this case, the officer has laid out his subjective intent before us. He said, "I did not intend to arrest him until after he said those words." And we also have him saying in the same affidavit on page 4 in paragraph 5 that people were recording each other a lot during this Occupy movement protest. And so we have him both admitting that the recording of individuals is ubiquitous, and we also have him admitting that he decided to make this arrest after he knew the likely content of the recording. But if you're uncomfortable with drawing the line so narrowly, we can address the wiretapping statute itself to see, and my second point, that applying it in this case would be overbroad.
Well, maybe we don't even have to get there. Let me ask you this. Suppose we concede that you're right on the First Amendment, and suppose we concede that you're right on the Fourth Amendment. Lotke raises an interesting question, though, and that is, look, if the district judge and the circuit court reached contrary opinions and the cases are irreconcilably in conflict around the country, how can we possibly conclude that it's clearly established, even if I personally might think that it was quite clear?
Respectfully, Your Honor, it's a valid question. When case law differs, law isn't clearly established. The argument we make here, however, is that the case law is clearly established. When reading a case, it's important not just to look at the holding, but the reason and the rationale that supports it. That's why we have written opinions. In, for example, Kelly versus Borough of Carlisle, the case that held in the Third Circuit that there was no clearly established right to videotape during a traffic stop, the very specific reasoning of that case relies on the inherent dangerousness of a traffic stop. And for something to be inherently dangerous, it means that it's dangerous without any further inquiry. We just know that it's dangerous. Every traffic stop can be presumed to be dangerous. Protests, especially peaceful protests that have been going on for 4 weeks, as is demonstrated in this record, do not raise such a presumption.
But you're addressing the answer to Judge Martone's question at too high a level of generality. The issue is whether or not there's danger inherent in videotaping and filming and recording an undercover officer speaking to a member of his police force while working in undercover capacity. That's inherently dangerous, is it not?
Yes, Your Honor, it is inherently dangerous.
So that's the end of the ballgame.
Not necessarily, Your
But
Honor.
what would you have him do? What should Lotke have done under your view of the case?
Well, I think it's dangerous to second-guess officers in the line of duty.
No, that's exactly what we're being asked to do in a case in which the claim is under 1983 and the defense is qualified immunity.
What I think qualified immunity gets to, Your Honor, is not to second-guess.
Well, what should he have done?
Reasonably, he probably should have just removed Phelps from the scene. Instead of snatching someone's cell phone, searching the cell phone to see if a video was posted on a publicly available website, and then arresting and dragging someone to the station house for charges that were eventually dropped. The prosecutor dropped the charges under the wiretap.
If he had grabbed him and taken him away from the scene against his protest, you would have been happy to walk away and not file a 1983 lawsuit.
I was talking about Officer Phelps, who was
I
the
know.
undercover officer. Yes, Your Honor, that's right.
You would not have filed a lawsuit. You would have thought that was perfectly legitimate under the Fourth Amendment, to take somebody against his or her will without probable cause and remove them from a place where they are peaceably and lawfully placed.
Respectfully, Your Honor, I may have been confused on the facts. My solution for Officer Lochte was to go to the undercover officer, Mr. Phelps, and remove him from the scene. Say, Mr. Phelps, it's dangerous here.
At a time when your client is filming.
Respectfully,
Listen, he's filming.
Not at
He's
that
figured
moment.
out that you're undercover, so it's really good for us to get out of here right now. And then your client continues the filming, finishes the clip, and hits send. Now what?
Respectfully, that's within his First Amendment rights. He's reporting on police conduct. And just because it's inconvenient for the police, or just because the reaction to that First Amendment conduct may be bad for the police, doesn't mean that the police get to step in and say, no, you can't report on that.
So there's nothing he could have done.
Respectfully, to prevent the posting of the video under the First Amendment, no, because none of the First Amendment exceptions apply here. On to the issue of the wiretapping statute itself, though. Time, place, and manner restrictions have to be judged under intermediate scrutiny. So we ask, is there a compelling government interest? Are the means narrowly tailored to achieve protection of that interest? Have we cut off...
Forgive me, but I'm still struggling with some of the underlying issues for qualified immunity. In my experience, damage actions under Section 1983 are really poor vehicles for the vindication of constitutional rights. And as you can see here, you've been in 3 courts now addressing the question of qualified immunity, drawing nuanced distinctions that boggle the mind. Why wouldn't just a state tort claim have been sufficient in this case? Bring count 1 for false arrests, count 2 for trespass to chattel. Why waste everybody's time with respect to trying to constitutionalize what is basically just tortious conduct?
Because the Congress enacted Section 1983, Your Honor.
But the court created qualified immunity to try to bring some reason and limitation to it so that we don't constitutionalize the law of torts, didn't it?
That's right, Your Honor. State tort claims may still stand, but what my client seeks is vindication of his constitutional rights.
Is it easier to bring an action under 1983 than under state tort law? Is that why you did this?
Respectfully, Your Honor, the federal courts, since their beginning, many argue exist to vindicate federal rights in a way that state courts might not.
No,
And
state courts are perfectly competent to handle federal constitutional claims. They've been so since the founding of the Republic.
That's right, Your Honor, and there's some argument that state courts originally were supposed to enforce federal rights. But in the end, we had a Supreme Court who, at the very beginning, in the text of the Constitution, without action of Congress, was constituted to be the final arbiter on the law of the land, the law of the United States. And ultimately, this is an appropriate place to bring those kind of concerns. State courts are certainly able to hear Section 1983 cases, but it shouldn't be the fault of a plaintiff because he chose a venue he thought would be more likely to fairly hear his claim.
Well, did the plaintiff choose this venue because if he prevails, he might get his attorney's fees under Section 1988, and if he brought a tort action under state law, he would not? And so, as a lawyer who's interested in getting paid, you're not interested in the state tort?
Respectfully, Your Honor. Well, I see that my time has elapsed. May I briefly conclude?
Yeah, please finish the answer.
We urge this court to affirm the holding of the 14th Circuit and find that qualified immunity is not appropriate on the First Amendment issue, regardless of whether state tort actions may lie. Thank you.
Thank you.
Thank you very much.
Good afternoon, Your Honors, Mr. Chief Justice, and may it please the Court. My name is Sara Gruen, and I will be arguing the Fourth Amendment issue on behalf of Michael Franklin. Your Honors, it is clearly established under this Court's precedent that no officer may perform an arrest nor search incident to that arrest without probable cause, meaning a reasonable ground for the belief that the arrestee is actually guilty of a crime. The petitioner attempts to avail himself of the search incident to lawful arrest exception to the Fourth Amendment's warrant requirements. However, before that exception becomes available, there must be a showing of a lawful arrest based on probable cause, and here there was none, nor could any officer have reasonably believed there to have been probable cause for 2 reasons.
So your client didn't violate the wiretapping statute?
No, Your Honor.
Okay, can you tell me, did he record someone's conversation without consent?
No, Your Honor.
Whose consent did he have?
He had the constructive consent of Officer Phelps.
Constructive consent, okay. The statute doesn't speak about constructive consent.
No, Your Honor, it does not.
Okay, and how do you get that concept into the statutory text?
Your Honor, for 2 reasons, the officer had noticed that not only was the consent element not met, the secret element wasn't met, nor the oral recording element. And that comes first from the plain language of the statute, but also the interpretation of the First Circuit in Glick versus Cunife. And also, in Glick versus Cunife, the First Circuit analyzed an identically worded limiting provision to the Massachusetts state wiretapping statute, that is the intercept provision. And the Glick court determined that recording in plain view could not satisfy the secret element of the statute in question. And
No matter how far away you are?
no matter how far away you are.
How could that not be secret? If I'm 500 feet away and I've got recording device that is so good that it captures someone's conversation, two people sitting on a park bench whispering to each other, how
Excuse
could
me,
that not be secret?
Your Honor, I misspoke. I think there would be a limit around distance. What the court was looking for were objective manifestations of notice to the person who was the subject of the recording. And in that case, Mr. Glick was standing with his arm outstretched, the recording device plainly visible to the police. The police approached him and asked him what he was doing. In that case, they actually had an arguably greater grounds for probable cause because they asked whether his phone was picking up oral communications, and he confirmed that it was. Nevertheless, the First Circuit determined that in light of the case you've already heard about today, Commonwealth versus Hyde, which is the only sustained conviction in this country of a person for recording officers in the course of their public duties, and that involves someone having a recording device secreted inside of their clothing, that in light of that decision, the secret term required required only constructive notice to be not met as an element.
How can you give constructive notice if you don't know that it's going on?
Well, Your Honors, in that case, the court looked to the fact that the police could see Mr. Glick recording, he was close enough, and in this case, we have an even greater grounds to believe that not only was there constructive notice, but there was constructive consent. First, as the petitioner has described, recording of the events of the protest was nearly ubiquitous. The cameras were constantly picking up what he calls the exploits of the protest and posting them online. Furthermore, Officer Phelps had volunteered to serve as the public face of the protest and frequently featured as a prominent public figure in the protests and on these videos.
But there was a uniformed police officer there who would also have had to been given, had given consent to this as well. And he had not participated in the movement's activities.
Yes, Justice Rochford, with regard to the uniform officer, it's not as likely that there would be consent, but there certainly would have been notice that the cameras were rolling because of the existence of the 99%.com website, because of the way in which cameras were ubiquitous, and the way in which these protests had been recorded.
How long had the protest been going on before the events here?
A month.
And yet, your client had not been able to capture the undercover officer engaging in any of these conversations with his fellow uniformed officers for over 30 days. So why would there be any belief on the part of the undercover officer that that sort of matter was being taped?
It's not the subject matter of what's being taped. It's not the subject matter of what's being taped that's relevant. It's the fact of being taped that's relevant. And so if this officer had wanted to have a private conversation, it's debatable whether while performing these types of duties there's any right to privacy, but we're looking to at least a very restrictive analogous statute, the Massachusetts statute, which criminalizes secret recordings. But what we're saying is this officer had constructive notice that he could potentially be recorded at any time and chose to have this particular conversation in a public forum in the park itself.
Let me ask you this. One of the things we may choose to do here is what we do in lots of other cases, and that's engage in balancing. And in this case, when one measures the marginal utility of your client's conduct against the utility of the officer, Lotke, how does that equation balance out? Here's a guy who is trying to protect human life. trying to avoid violence, doing it perhaps awkwardly and maybe even stupidly. But that's his goal. He's not really a Nazi. And then we have your client who's bringing a 1983 action whose goal is damages, money damages to compensate him for some loss of his. But in measuring his loss, it's pretty hard to see what the loss might be other than maybe the embarrassment of the incident. So if we engaged in that kind of social utility balancing, who wins here? The police officer who is trying to protect life, or your client who is seeking a modest sum or maybe nominal damages under Section 1983?
Justice Martone, I want to break, hopefully, that question down into several pieces, and first weigh the notion that's been hinted at by the petitioner that there was some sort of danger to Officer Phelps to which he was protecting. He's hinted that my client was doing something akin to threatening this officer, endangering this officer, but if my client were actually engaged in that kind of conduct, what he's alluding to is criminal conduct. And we would expect to see something like reckless endangerment, terroristic threats, alleged as the basis of probable cause. Because the facts and the record don't bear that out, you don't see it actually alleged as an independent basis of probable cause. So that's one hole in the danger argument. Another is that there's something strange, at least in my mind, about this officer posing an elaborate hypothetical about how Officer Phelps is going to become endangered, in that everyone around the arrest will, or everyone around the recording will suddenly tap into their phones, become violent, and attack Officer Phelps, but disregards the danger from these, in his view, this ravenous crowd, that they would have overheard some of the exchange during the arrest, that my client might have shared his suspicions with some of his fellow protesters, and that this singular event, this first arrest of the entire protest, would have drawn attention to itself. And yet he left the scene, left Officer Phelps there, and there was no indication that he wanted to remove Officer Phelps. So I think when we look at the danger concept, it falls apart. And the reason is because this was a remarkably peaceful protest. In the entire month that the protest had taken place, there was not a single arrest, and that can't all be attributed to Officer Phelps's work. The fact that there wasn't a single marijuana arrest, a single petty altercation that resulted in some kind of domestic dispute is really rather remarkable. This was a disciplined crowd. And as to the vindication of constitutional rights, one, I would just point your Honor's attention to my co-counsel's argument about the importance of First Amendment rights, and that this court has affirmed on multiple occasions the principle that officers are expected to endure a fair amount of annoyance, harassment in the form of First Amendment speech, because First Amendment protections are so important. And second, I would point your attention to Justice Harlan's concurrence in Monroe versus Pape, talking about the sanctity or the importance of constitutional rights and the importance of 1983 as a special vehicle for vindicating constitutional rights that deserve their own remedy outside of state tort actions.
Can I turn you to qualified immunity for a second? You've given us a very intelligent and nuanced view of how this wiretapping statute should be interpreted to avoid constitutional problems. But how would a reasonable, objective police officer think that that is the way that that statute is going to be construed by a court when acting upon it?
Your Honors, Glick versus Cuniffe was a 1983 case, and the decision was that there was no probable cause, and no reasonable officer could have thought that there was probable cause based on the language of the statute. So with that case on the record, this officer is on notice that there is no probable cause in this case.
Where's that case from?
It's from the First Circuit.
So once,
But that case didn't say that its decision would apply across the board, that there would be circumstances that it wasn't willing to address